All right, ladies and gentlemen, this is the video tutorial for Jim Crow laws and racial segregation. I apologize for my voice, as my voice is gone, obviously, and I'll try to do my best. But we just finished these notes, and remember, the first half is kind of a fill in the blank. The second half is a compare and contrast of W.B. Du Bois and Booker T. Washington. So what you can do is you can make a comparison. Your comparison chart, if you haven't already, you can fill it in. The information that I have here needs to be on it, whether you complete it or not. And I'll explain as we get there. So first of all, what Jim Crow is, we all know Jim Crow as is the division, the segregation of whites and blacks in the South. That occurred after 1877 when President Rutherford B. Hayes, a part of his deal to become president, remember there was a tie in the Electoral College. His deal was to remove federal troops, and thus federal law was not being enforced in the South. So southern states created the black codes, reemerged as the Jim Crow laws. And what it means is basically, based upon race, you have, and primarily directed against African Americans, you have the division. Whites could attend this theater while blacks could attend these theaters. Or if it was the same theater, they'd be separated in the same building. This is this is when you had the segregation of the drinking fountains that you saw above, or bathrooms. The idea was to keep blacks and whites separate. There was a thought that if the two mingled, there would be issues between both of them, and they would never get along. And that was a case of long, drawn-out tradition of racism. Then this time period of Jim Crow lasted up until the 1960s. So groups were discriminated, other groups were discriminated as well. You had a large Latin American Latino population in the Southwest, and they too were segregated. Native Americans were segregated. They were even considered citizens until 1924. As you can see with this image that I have to the right, you see that the sign saying no dogs, Negroes, or Mexicans. This is an actual sign that was put on someone's door. This wasn't considered to be, this is obviously racist, but wasn't considered to be any form illegal. You were allowed to restrict entry to buildings in accordance to, in regards to someone's race. And the worst part about this picture, about this sign, is that it compares African Americans and Latinos to dogs. And not only that, the dogs are listed before. So this is truly made to insult. We don't need to see the video. All right. The discrimination against African Americans, you had, they were legal in communities and states. There were actually laws. They weren't, hey, Fred's store can do what he wants. If Fred wants to not allow African Americans to shop at his store, he can do it. It wasn't that. It was literally, it was illegal for Fred to let whites and blacks work in the same, or go to the same store. There was no choice. It was all segregated. And it was legal in communities and states. The thing is, some states allowed the cities or counties to make the decision as to whether they're going to segregate. Kansas was one of them. And we'll talk about that later with Brown versus Board of Education. That actually has to do with that phenomenon. The other is, like most cases, like in the South, like in Virginia, you had actually state laws that segregated whites and blacks. Now, you might be thinking, well, wait, Mr. Carley, what about the 14th Amendment? The 14th Amendment, which was the amendment that that stated, which says that a citizen cannot be denied life, liberty, or property without due process of law. And if African Americans are considered citizens, they have the right to liberty of life, liberty, and property. By having segregation, you're imposing someone's liberties. And that itself, it's unconstitutional. And you might think, well, how on earth did this happen? How do these state laws emerge? Well, under our government system, if you're going to contest a state law to federal law, it has to go through the judicial branch of government. Which means you have to sue the state or appeal from the state a criminal case in accordance to the law or the amendment. So in this case, as we're talking about Plessy v. Ferguson. First of all, it's characterized by unequal opportunities in housing, work, and education, and this is obviously here. Mr. Plessy was this is in Louisiana. He's I want to say fourth generation inclusive or fifth generation inclusive African American. So his great great grandparent, either grandmother or grandfather, was African American, and if this was Virginia, he'd be considered white, but in Louisiana, it's a blood code. So you have any percentage of African American in it, you are considered African American. So you look at Plessy's, looked more like a darker colored white, darkened color white. So that's why he bought a ticket on a train to get to Covington, Louisiana. The guy that sold him the ticket thought he was white, so he sold him a first class ticket. Buys first class ticket, sits down, then comes in the porter or conductor. When they check your ticket, they check your ID. In Louisiana, in Louisiana, in any state, when you're in a train, when they look at your ticket, they look for your ID. In Louisiana, you had to put your race on your ID, and his Louisiana identification said he was black. Well, because of that, he was told to move to the colored only car. They couldn't sit in first class. Now I say that word colored only because that's what they labeled it as. He refused and was ticketed and then arrested for disorderly conduct for his actions on the train. Well, they went to court. The judge said he's in violation of their segregation laws, and he was fined and given some sort of punishment. Well, the judge, his name was Ferguson, but hence why Plessy v. Ferguson. Well, he appeals to the federal court, and it moves all the way up to the Supreme Court. The Supreme Court hears this case. And when they heard this case, they thought, well, now keep in mind, this is the context of 1896. They thought, well, Plessy could have gone to Covington. If Plessy would have ride the first class seat or was seated in the African American only section, then he would still get to Covington at the same time as a first class seat. So because of that, his liberty of travel was not taken away. He still could get to his destination. So what they looked at was that the situation, you can have segregation. This became the status quo. So listen carefully. They said that you could have segregation so long you could be separate. So long as you were equal. The idea was separate but equal. If you have a white drinking fountain, you have to have a black drinking fountain. If you have a white school, you have to have a black school. If you have a white restroom, you have to have a restroom for African Americans. That doesn't mean that the one drinking fountain, which might be better than the other, that doesn't mean that they have to be equal in how good they are. That just means that the liberty is to drink water in a public fountain. So if we go back to this drinking fountain here, you see that the whites only drinking fountain looks like some water conditioner, kept it cool, and the blacks only drinking fountain is directly from the tap. This is still regarded as equal, under separate but equal, in accordance to Plessy v. Ferguson. So, the thing is, 1896, it wouldn't be until 1954 that the idea of Plessy v. Ferguson, or separate but equal, would be overturned. And the reason, because of this, the only person that can overturn a Supreme Court decision is the Supreme Court. And Supreme Court justices are not elected, they're appointed, and they serve for life or until they decide to retire. So you basically have to wait till all the Plessy v. Ferguson justices are either dead or retire and then are replaced by more progressive thinking judges, somebody that wants to push for change. And that happened in 1954. That was Brown versus Board of Education. So the status quo changes the court's decision by 1954. So 1896, people had no resentment against these laws. At least by when I say no people, I mean the governments. So no person. So here's an example: no person or corporation shall require any white female nurse to nurse in wards in the same rooms in hospitals, either private or public, or private, in which Negro men are placed. So white nurses cannot take care of African American men. You can't marriage of a person of Caucasian blood with no Negro, Mongolian, Malay, or Hindu. Now Mongolian is reference to Chinese. Malay is reference to anyone in the Pacific Islands. It's including Vietnam, Cambodia, and Thailand, so French Indochina, who are not Malaysian. And Hindu represents anyone from India all the way to the Middle East, which Hindu itself is a religion, so it just makes this whole thing pointless. But nonetheless, you have Arizona that says you can't, if you're not even the same race, you cannot marry. That's essentially what that's saying. Marriages between white person and Negro are prohibited, except for situations where there's someone of Negro descent of the fourth generation inclusive. So that means that if you in Florida, if you have a fifth generation African American ancestor inclusively, then you're not considered African American. But yet in Louisiana, like we talked about with Plessy v. Ferguson, he was. No colored barber should serve as a barber to white women or girls. By the way, you don't have to write these down. If you're writing these down, you don't need to, so stop now. But these do not have to be written down. This is just some examples. So the idea of separating women from men, especially black men from white women, was a big part of these Jim Crow laws. Officer in charge now bury or be buried any colored persons upon the ground set apart for burial of white persons. This is quite common in the South, including Virginia. There's still segregation even in cemeteries. It's unlawful for someone to frequent a park owned and maintained for the benefit and enjoyment of white persons, and it's unlawful for a white person to frequent a park owned and maintained for the benefit of colored persons. So the thing is, it works both ways. So if you're a white person and you're violating a Jim Crow law, you too will be fined. So it worked both ways. So whites couldn't mingle with blacks, and blacks couldn't mingle with whites. Board of Trustees shall maintain separate buildings on separate grounds for the admission, care, and instruction of all and support of all blind persons of colored or black race. So that's even those who are blind are considered are not allowed are segregated. And even in convicts in this case, convicts shall be separated as well. So it went all the way. This is how this extent. And when we get to the spring this year, I'm going to show you guys just how these type of laws, these type of rules of Jim Crow South emerged inside the pop culture, and how people saw things that are blatantly racist but didn't realize it because it was considered normal. So next case we have Booker T. Washington versus W.B. Du Bois. This is a comparison chart, so you have either a Venn diagram or a double bubble map that you already made or you need to make now, so you need to do so. You need to add these. So these are differences. Booker T. Washington, the difference between Booker T. Washington and W.B. Du Bois is that Booker T. Washington believed equality could be achieved through vocational education. That means work training. He says the American public would not appreciate African Americans unless they can be competitive in an industrial job market. And to do that, he needs to give people training on doing industrial tasks, welders, plumbers, steel workers. All of those tasks need to be there so businesses can see that African Americans are a strong workforce, and they will force states to take away segregation laws so they can have African Americans work in their factories. But in the time being, though, he said that they can't fight against segregation. It's there, and it's going to take time. And for now, you got to accept social segregation until society can see that African Americans are helpful for the public. And at the time being, people didn't think, especially those in power, did not believe so. And that's what he said, essentially this idea of taking time. Integration will take time. He believed in integration, but he knew that he just thought it won't be as quick. It needs to take time. You got W.B. Du Bois, though, on the other hand, believed in full political rights for African Americans. He wanted full social rights, civil social rights. He wanted full economic rights. Now, you don't have to put a different circle or a question for one of these. You can just say believed in full political, civil, social, and economic rights. But he truly believed in equality now. He wanted immediate integration of American society. African Americans didn't need to prove anything. They're citizens, and they deserved that equal rights. So you had these two philosophies, one more conservative, like Booker T. Washington's, one more radical, like W.B. Du Bois. And this was these were the big philosophers of that time. W. Du Bois created the NCAA, or NAACP, I'm sorry. NAACP is the National Association for the Advancement of Colored People. And while Booker T. Washington creates Hampton, the Tuskegee Institute, one of the founding members of the Hampton Institute or Hampton University. Hampton University focused on vocational education. W. Du Bois really wanted to push for that traditional education, more African Americans as leaders, like lawyers or doctors. They both believed in equality, but they just believed that equality could be achieved at different times. Booker T. Washington said later, W.B. Du Bois said he wants it now. And that is your Jim Crow. So go ahead and fill out your notes. If you have any questions, please contact me as soon as you can.